State of Michigan versus Scott Stevens, 224030471. Mr. Stevens, are you on?
Yes, can you hear me?
Yes, could you state your name, please?
Scott Stevens.
Mr. Stevens, you are here today on a limited access speeding ticket. This was issued to you on March 13th, 2022 on US 23 in York Township. The ticket is for 16 to 20 miles per hour over the speed limit, 88 in a 70. The penalty for that is $160 and 2 points on your driving record. You can admit responsibility or we can have a hearing. What would you like to do?
I'd like to have it.
Hey, ma'am, Trooper Smith here. Sorry, this is my citation. I'd like to offer him 6 to 10 over, as he was very respectful on scene.
Okay.
That way, you know, it will lower the points and the amount for Mr. Stevens here.
Okay. So, Mr. Stevens, you're being offered an opportunity to admit responsibility to a lesser citation, 6 to 10 miles per hour over the speed limit. That is 1 point. And you also are eligible to do a driver improvement course through the Secretary of State to keep that 1 point off your driving record if that's something that you wanted to do. So are you interested in admitting to the lesser citation?
Not a
The trooper personally steps in and says, "This guy was respectful, let's reduce it." That alone should be setting off alarms for viewers, because most people never get that level of courtesy. Reduced points, reduced fine, and even a path to keep the point off his record entirely. This is the courtroom equivalent of being handed a lifeline. And yet, instead of taking it, Stevens hesitates. That tells us this isn't about the money or the points, it's about pride. And when pride walks into a courtroom, it almost always walks out lighter. The judge is calm, procedural, and methodical, while Stevens sounds confident, maybe too confident, that he can talk his way out of this. But here's the twist most defendants don't realize. Traffic court isn't about who talks better, it's about credibility. And once credibility starts slipping, the entire case unravels fast. Keep watching, because the difference between a 1 point slap on the wrist and a full conviction is about to come down to Stevens' own words.
Raise your right hand. You swear or affirm that the Trooper Smith, is your hand raised?
Yes, ma'am.
Swear or affirm that the testimony you're about to give in this matter is the truth and nothing but the truth?
yes.
Okay, Trooper Smith, do you swear?
Yes, ma'am.
Okay, so Trooper Smith will testify first, Mr. Stevens, and then you can tell me whatever it is you'd like me to know after he's done. When you're ready, go ahead.
Yes, ma'am. On March 13th, approximately 1:20 in the morning, myself and Trooper Tweetmeyer were doubled up in York Township on US 23. We had our front radar activated in my patrol car. It had been tested prior to my shift and at the end of my shift. Both tests passed. I am radar certified and have been for quite a while. A black GMC passed us, and it was going approximately 88 miles an hour on our front stationary radar. As it passed us, we received the reading, and then it continued on, hit its brake lights, slowed down to 84 miles an hour. We ended up stopping the vehicle and made contact with Mr. Stevens. Should be noted, Mr. Stevens has extensive driving history, 7 prior speeding on his record.
All right, thank you. Go ahead, Mr. Stevens.
And there's no way I was going that fast. That's all there is to it.
How fast do you think you were going?
75.
Okay, so then how do you explain the radar reading of 88 and then 84?
Well, I don't know if he clocked somebody else or what the case was.
We'll ask him. Were there any other vehicles in your radar range, Trooper Smith?
Ma'am, I don't recall at the time, but being at that time of the night, US 23 is very minorly congested. There's very limited traffic. So I couldn't imagine us both making a mistake of clocking a different vehicle at that time.
Okay, thank you. Go ahead, Mr. Stevens.
I don't know what he meant by both of us clocking.
There were two troopers. Were you in the same vehicle?
Yeah, yes, ma'am, we were. And on top of that, too, Mr. Stevens advised he was going 80 something miles an hour when talking to him.
That's what he told you at the stop?
Correct. Yes, ma'am.
Okay.
I definitely did not say I was going 80 something. He might have told me that he clocked it at 80 something, and I might have said I may have been doing 80 possibly somehow, not wanting to argue with him at the time, but there's no way I said I was doing 80.
Well, there certainly is a way that you said that. I mean, I maybe you don't recall now, but Trooper Tweetmeyer has in his notes that you said that. He's not just remembering that. He made a contemporaneous.
Right here is where the case quietly starts tilting against Mr. Stevens. The trooper doesn't just say he clocked the speed, he explains how, when, and why the radar reading is reliable. Tested before and after the shift, certified operator, stationary radar, and a clear reading as the vehicle passed. That's not fluff, that's foundation. And then comes the detail that really matters: 7 prior speeding tickets. Judges don't ignore patterns, even if they don't say it out loud. When someone with that history says, "There's no way I was going that fast," the court immediately asks a different question. Why should we believe you now? Stevens gives a flat denial, but notice what he doesn't give: any concrete explanation. No malfunction, no slope, no pacing error, no specific challenge to the radar. Just disbelief. And disbelief alone doesn't beat evidence. This is where a lot of people think confidence equals credibility, but in court, documentation beats certainty every single time.
Note at the time. And so which is it? Do you think you were going 80? Do you think you were going 75? What do you?
I think I was doing 75.
Okay.
Was the video?
But you don't know?
Well, no, I'm not positive, especially when he come up and said that at some point that he said I was doing over 75.
Yep.
It seems like is this day and age, we'd have video of this car going by at 80 or whatever it was. Do we?
Do you have video, troopers?
Yeah, yes, we do, ma'am. If you'd like to set up a formal hearing. With this being said, I think the state rests his case. Clear weather, dry conditions, light traffic, being dark, having 7 prior speeding tickets, and saying he was going 80 something miles an hour.
Okay.
That's your statement.
Right. Well, that's exactly that is his statement.
And my statement is I did not say that.
Okay. And your statement is also that I don't hear you today saying that you know how fast you were going. So typically when someone sees a police officer's lights in their rear view, they look at their speedometer, like it's just habit. So did
Correct.
You do that?
Absolutely, I did.
Yep.
Right. What was the speed when you
Yeah,
were
I'm
behind?
asking you.
I looked down. It was like 75 miles per hour.
Well, like 75, or it was 75? You're being pretty vague.
Well, the speedometer didn't read in numbers. It's got a number on there with a dial. And when, like you said, when I seen the lights there, I looked down. Well, I didn't just sit there and study it. I mean, I was watching the road and I was trying to.
So you
pull
don't know
over.
how fast. You don't know how fast you were going.
I know it was nothing over 75 miles per hour.
But you don't know. You don't know that. That's what you believe. That's what you're telling me. You think, but you didn't look at your speedometer. You can't explain.
I did look at my speedometer. It was not over 75 miles per hour.
Okay. I'm finding you responsible today. I don't find your testimony credible, and I believe that the state has met its burden of proving that the ticket was properly issued to you. So I'm finding you responsible for the ticket as written, 88 and a 70. The fine is $160. You have the right to file an appeal and have a formal hearing with Judge Freshour. If you would like to do that, you have 7 days to file the appeal. You can call the court and the clerks will tell you how to do that.
Okay, we'll see the real judge in 7 days. Thanks for your time.
Thank you.
This exchange is critical because it exposes a contradiction that Stevens never recovers from. First, he says he was doing 75. Then he says he might have said 80, possibly. Then he says there's no way he said 80. Meanwhile, the trooper isn't guessing. He's reading from contemporaneous notes written at the time of the stop. Judges trust notes made in the moment far more than memory recalled months or years later. And notice how the judge presses him gently but firmly. Which is it? 75? 80? Or you're not sure? This isn't badgering. This is credibility testing. And every time Stevens hedges, the ground underneath him cracks a little more. Courts don't expect perfection, but they do expect consistency. And right now, Stevens is offering explanations that shift depending on the pressure. That's not how you win a credibility contest.
1290. Mr. Talaski, this is a ticket issued to you for disobeying a stop sign on Carpenter near Stony Creek in York Township on March 15th, 2022. You have requested to have a hearing on this matter. So if you could please raise your right hand, let me know your hand is raised. Deputy
Yes.
Richardson, I need your hand raised too. Do you swear or affirm that the testimony you're about to give in this matter is the truth and nothing but the truth?
Yes. Yes.
All right. Deputy Richardson will testify first. He is going to tell me why he wrote you the ticket and show me the video, and then you can tell me whatever it is you want me to know when you're done, when he's done. Okay? When you're ready, Deputy Richardson, go ahead.
I'm just pulling up my ticket real quick. I apologize.
It's all right.
I'm pulling up the ticket real quick. I do have the video. I just have to get the ticket to load.
Go ahead. Drinking disregard. The update kit here. Sir, for ticket so you can disregard. Take the trail, sir. Thank you.
All right. Alrighty, on March 15, 2022, approximately 9:12 p.m., I was in the area of Stony Creek Road and Carpenter Road. I was parked stationary on the northwest corner there. There's a little small auto shop building there, and I was there for the purposes of observing the stop sign and people disobeying the stop sign. On that date, I observed Mr. Brian Pulaski driving a 2004 Chevrolet Silverado, silver in color, as he traveled southbound Carpenter Road towards Stony Creek Road. As he approached the intersection, he rolled the stop sign. It did not come to a complete stop, and I then initiated that traffic stop and issued him a citation for that.
Okay, thank you. Go ahead and show your video when you're ready.
All right, let's back to here.
I'm not really seeing the video. I don't know.
It's not playing yet, sir.
Oh,
Yeah.
Okay, can you see that now?
coming on. Here it is. Go ahead.
Okay, all right.
Let me see. I think I might have hit the wrong screen. Let's go back. I'll do this. Stop share. Share screen. This one. Share. All right, is this one here?
Here's where frustration starts leaking through. Stevens brings up video, a common move, but notice how it backfires. Yes, video exists, but instead of helping him in this moment, it reinforces the state's position that they're prepared, documented, and confident. And when the trooper lists the surrounding conditions, clear weather, dry roads, low traffic, nighttime visibility, he's quietly removing every excuse Stevens might rely on later. There's no rain, no congestion, no distraction. This becomes a clean case. And Stevens' denial now has to overcome not just radar, not just testimony, but context. The judge is listening carefully, and you can almost hear the mental checklist being filled in. When defendants assume video is a magic escape hatch, they forget one thing. Video cuts both ways.
So on the right of the screen, you'll actually see the building in the darkness. You can actually see the reflection of his headlights as he approached the intersection, which will be consistent with him as he continues southbound, where you'll see where there's no stop, he grows the stop sign.
Okay.
And I'm playing it now. It's only going to take about 25 seconds-ish. And that's not his vehicle.
It's not him. All right.
Correct. That vehicle's on Stony Creek. This is going to be him approaching here.
Were you able to see that, Mr. Tulaski?
No, I don't see it right now, ma'am. Go ahead. Well,
You can't-
can I do
you can't-
play?
You didn't see the video?
No, I haven't seen it yet. No.
Okay. Can you tell me what you see on your screen?
The blank screen. It says viewed by Richardson.
Okay. Now, what do you see now?
I don't see anything.
All right. So Deputy Richardson is playing the video for me, and you don't even slow down at the stop sign.
I don't see that. Yeah, I don't see anything.
You can't see the video. All right.
Yeah. Oh.
Well, I have seen the video, and there's Deputy Richardson has a clear view of the stop sign at Carpenter and Stony Creek. Your vehicle drives straight through the stop sign without even slowing down.
Okay, that's not true.
Well, that's what the video shows me, so I don't know.
For one thing, I don't know who Richardson is. If he's a male, then he would dress like a woman. This was a woman.
Well, all of the sheriff's department deputies wear the same uniform, so you're right. Deputy Richardson was dressed like a female sheriff's deputy on that day. That's true.
He was?
Sure, they all wear the same uniform.
Well, wait a minute. No, okay. Now here I have a video. Okay, go ahead.
Oh.
Can you see the video now?
I see a video. I see lights. I don't know where the lights are. Do they come oncoming or are they?
Okay. Can you see a stop sign in that video?
37, again, 734, 717, what?
No, I don't see anything right now. It's something there. Okay, here's a stop sign. I see a stop sign.
Now watch.
This is the moment where Stevens' argument collapses under its own weight. He insists he looked at the speedometer, but then admits he didn't really look. He says it read like 75, but can't explain where the needle actually was. That vagueness is fatal. Judges know exactly how people behave when police lights come on, and the judge even explains that habit out loud. Stevens is fighting the judge's lived experience, not just the ticket. And when he insists, "I know it was nothing over 75, the judge cuts through it. That's what you believe. Belief is not evidence. And once the judge says she doesn't find him credible, the case is effectively over. The ruling just hasn't been spoken yet.
The stop sign. This is your vehicle approaching.
Put her next, please.
And driving right through. What kind of truck do
Okay,
you drive?
now, okay. That doesn't show me stopping. Okay,
Right.
It doesn't show it stopped. I stopped. Okay. However,
What kind of truck do you drive?
a Chevy 2004 Chevy. Go ahead.
Okay, so that is your car,
Yes.
a pickup truck that went through the stop sign
It didn't go. I went through the stop sign, but I
without
stopped.
stopping.
I stopped.
Well, sir, the video does not show that you stopped. It shows that you did not
that video is not a very good video. Please.
Okay.
And
It's good enough.
Go ahead. I travel that area since moving from Whitmore Lake to Monroe, and I try that every day because I have goods and I have animals that I have to feed every day. That's 50 miles a round trip. Okay. So when I come down that day, I just chose to do Carpenter to Willow to Whitaker. That was a route. And when I come to that sign, I slow down. The blinking light is stop, go, stop, go, stop, go. There's no time on there. There's no meter. So when I came to that spot, I stopped. However it was, and then I went through, and I was accelerating from 0 to 40 miles an hour when this officer pulled me over. Okay, and it was not a male Richardson type voice. It was a female.
All right.
So I don't know where he got that video, and unless he was sitting in the car with somebody, but it was definitely a woman. Go ahead.
Okay. Well, I think your perception of what occurred at that night is mistaken in several ways. The burden of proving that a ticket is properly issued is on the municipality. Today, that's York Township through the representation of Deputy Richardson. It's a very low burden. It's what's called a preponderance of the evidence, which just means if it's slightly more likely than not that the ticket was properly issued, then as the magistrate, I can and should find the defendant responsible. So I've seen the video. Deputy Richardson has testified, and it's clear to me that you did not stop at that stop sign and the ticket was properly issued to you. So I am finding you responsible for disobeying a stop sign. The fine is $130. You have a couple of choices. Okay, you can pay that within 10 days, or you can file an appeal and have Judge Freshour hear your case. If you want to file the appeal, you have to fill out the appeal form and pay the $130 within 7 days. You can call the clerks and they'll tell you how to get that appeal form.
Okay, I'm going to appeal, and I'll.
Okay.
Do I go to the courthouse and file for the appeal? Go ahead. You don't know?
Yes, you can file it at the courthouse.
Can I do it now?
Sure. The Saline Court is open today until 4 o'clock.
Oh, I have to go to the courthouse then, right?
You can come to the courthouse to file it. The fine has to be paid as part of the appeal. So if you would like to try